Place it down.
The court is in session.
The council seeks permission to approach the rise.
Please encourage this.
Greetings to the Honorable Bench. The Council acknowledges the gracious presence of the bench. However, for the sake of brevity of the proceedings, seeks the kind permission to collectively address the bench as Your Lordship. Much obliged, Your Lordship. If it may please Your Lordship, the next 21 minutes shall be my endeavour to argue before the Honorable Bench my two main submissions, that is, Issue 1 and Issue 4, and my co-counsel in the remaining 22 minutes shall deal with Issue 2 and Issue 3. Your Lordship, the Council reserves 2 minutes for the rebuttal round. Your Lordship, the Council is appearing on behalf of the petitioners bearing 3 writ petitions. All filed under Article 32 of the Constitution of India have been clubbed together by this Honorable Court. Your Lordship, the writ petitions in the order of their filing are: firstly, Salim and another versus State of Uttar Pradesh; secondly, MLAs of Uttar Pradesh Legislative Assembly; Ravi Ansari versus State of Uttar Pradesh. Your Lordship, if the Honorable Court is well versed with the statement of facts, the Council seeks permission to begin with the submissions. Much obliged, Your Lordship. Your Lordship, furthermore, in the state of Uttar Pradesh, Mr. a college student and son of tenant Stevens, an FIR was filed against Salim by a ruling party supporter, Mr. Zank, accusing him of inciting communal enmity between the classes. As per Section 27 of the Uttar Pradesh Urban Planning and Development Act 1973, hereinafter referred to as UPDA 1975. Your Lordship, aggrieved by this, Salim and his father petitioned this Honorable Supreme Court, challenging that the demolition as a violation of the fundamental rights. Your Lordship, furthermore, in Uttar Pradesh, political turmoil escalated under Chief Minister Rohit Kumar, whose administration faced dissatisfaction from Tribe B, a minority group in the state. Your Lordship, the Indian Progressive Party, hereinafter referred to as IPP, supported by Samaj political party, held a fragile majority. Your Lordship, amid this growing civil unrest and political instability in the state, the government was forced to undergo a floor test. However, Your Lordship, 40 IPP MLAs defied the party whip due to the ruling Indian Progressive Party of systematic marginalization. Your Lordship, in response to this, the government invoked the Unlawful Activities Prevention Act, hereinafter referred to as UAPA 1967, classifying some of the protests as unlawful and labeling certain Tribe leaders as terrorists. To be more specific, Mr. Ravi Ansari. Your Lordship, Ansari filed a writ petition challenging his arrest and seeking bail, arguing that his speech was misinterpreted and the charges were fake. Your Lordship, if the Honorable Court is now well versed with the statement of facts, the Council seeks permission to begin with the submissions. Much obliged. Your Lordship, before beginning with the submission, the Council has prepared a comparative. Your Lordship, I will be representing speaker. Shall I begin, Your Lordship? Much appreciated. Your Lordship, with regards to the first issue before the Honourable Court, it is most respectfully submitted that the practice of bulldozer justice fundamental rights guaranteed under the Constitution of India, and such actions they do represent an unconstitutional and boldly that how it abridges Article 300A of the Constitution of America. Boldly that how it abridges Article 300A of the Constitution of America. Your Lordship fails to pass the two-pronged test as laid down by page 5 of the Moot proposition. Your Lordship did other.
Yes.
The Church capriciously, irrationally, and without an adequate determining principle. Your Lordship, in order to establish that whether a provision. Para 7 page 2, it says that the state government of Uttar Pradesh has been actively progressing with its which the state claims it to be. This is the ostensible purpose. Users became a frequent and visible symbol. Expressly inferred that the ostensible
The purview of this
Development Act vests with the state government the power to demolish. Selim was not given a reasonable opportunity to be heard.
The owner is not established in the case of any legal.
This is what something the state. Selim was the owner of the property, is what the council is inferring from the expression used in the Moot proposition, ancestral to. Council is inferring from the expression ancestral. Yes, Your Lordship.
And so there was a kind of, very, suppose it was with clean hands.
There is only little time left. We would just concisely brief as to what are your points to say that the demolition.
First argument is that
What is the spirit of Article 14?
all of these constitutions have a legal spirit. Your Lordship, it is the most humble submission of the council that rule of law provides a framework to make sure that individuals.
You speak out.
Yes. Yes, Your Lordship.
Impediment in the free flow of the water in the canal or the river.
Yes, Your
Or
Lordship.
some
Position silent as it does not provide us the list of
Your map from the authority.
has the list of
Your map from the authority. So you,
as the contention of the council. As the contention of the council is concerned, what we are arguing is that
briefly what are Article 9
Much of- Much of that.
section 14 and section
arguments pertaining to the first reasoning and others. Hey, moving further with my arguments, it is the most humble submission that Article 308, that is contentions. Much obliged, Your Lordship. Your Lordship, with respect to the fourth issue before the Honourable Court, lawful and terrorist activities under the UAPA Act 1. Your Lordship, I shall contend this.
Am I audible to Honourable? The 10th schedule is in complete violation, Your Lordship. Your Lordship, the 10th schedule was inserted in the Constitution of India by the 50th.
before you go there,
Yes, Your Lordship.
this amendment 52. Come on that.
Sure, Your Lordship. Intending that,
Your
the
argument.
intent of the 10th schedule is to maintain the parliament constituents, Your Lordship. Your Lordship, when we talk about the election. Your Lordship, para 2 B says that if he votes.
The individual MLAs
Yes, sir.
represent a constitution, or
Yeah.
a constituency.
Yes, Your Lordship.
But the fact is, they per se do not come with any manifesto of their own.
Yes.
Does
Because they are being elected, and because they are being elected at the stamp of the party itself. But there exists two tribes.
whose call was that?
Your Lordship, it was the call of MLAs, but it was with regard to the
Based on what?
Unity is there. Party is under attack. Being the member of the party, taking care of Your Lordship, and these MLAs representing them have the duty to represent.
One tribe may have.
We have not the party.
Not rejected.
The present condition, the political crisis, the UN cried was the deputy speaker who disqualified him. Yes. The test that is represent Your Lordship, representation of people. MLAs doing in the best interest of people is their representation, Your Lordship. Yes, Your Lordship.
So, in your case,
Yes,
you
Your Lordship.
just apply any of the ruling and
Yes, Your Lordship, we can.
Digressing from the main point.
Yes, Your Lordship.
The issue. Because this is integral to the constitution. We are challenging that provision. So when we are challenging equally meaningful and equally all the constituent, the citizen, the voters might say, first, we don't want you now. Who from where did he get this extra power or extra mandate to change?
Main point being, we will require para members if we are going against the party or are abstaining from voting.
of the party.
It says if you go against it, it becomes a reason.
What are your further contentions?
And 1B simply states that the party can issue any directions. Your Lordship, this are not against the fundamental, against the infringement of constitution.
Will you clarify to this court the fundamental right of a society
Yes.
which will prevail?
When you talk about the
If there have been only one or two people, if Lordship, there is considerable amount of people involved in this matter. Your Lordship,
so what the
and would become a rubber stamp in the hands of his political party, Your Lordship, it also follows.
You're talking about the legislative.
Your Lordship, it also follows.
You're talking about the legislative intent.
Yes, Your Lordship.
What is the legislative intent?
Yes, Your Lordship.
What is the legislative intent
Yes, Your Lordship.
behind section 2?
So,
How can you forget one? We
There
are
are-
talking. This court want to know about the legislative intent.
yeah, but Your Lordship, in the present case, there is no.
regarding harmonizing parliamentary business.
The council is unaware of the present. Attention with regards to this issue only, that is, the speaker's majority tribe, and speaker is from tribe B. So it was majority tribe, and speaker is from tribe B. So it was not the speaker that disqualified the members, Your Lordship. It was the deputy speaker and authority under the Constitution, Article 180. Your Lordship, the procedure was such that
What is the duty of deputy speaker?
Your Lordship,
What is the duty of deputy speaker?
Your Lordship, and the counter understand the concern, Your
You
Lordship.
understand? You speak it out.
Yes, only when, Your Lordship, and the concern, Your
You
Lordship.
understand? You speak it out.
Yes, only when, Your Lordship, when the speaker is not there, that is he absent? The speaker and speaker are at par, but it has deputy speaker is
Once deputy speaker is authorized to act.
to the point, just for the sake of it, if I say that, so that I can fight my case before the parliament. Your Lordship, my simple objection is that speaker was absent and Your Lordship, I'll tell you the exact things what happened. Reading of the fact sheet, Your Lordship. In the absence of speaker on a subsequent day, the deputy speaker who belonged to tribe A to disqualify the dissenting MLAs. Next, That decision, lordship, there is so loopholes in it. So loopholes in it. Any direction is a terminology that will state that I do the murder and you have to justify and sign. You have to justify and sign it according to it. Your lordship, there needs to be certain situations that according to it. Your lordship, there needs to be certain situations that justify it. Your lordship, the legal position is the council is humbly contending that it is challenging the legal position of the 10th schedule here as well. Your lordship. Your lordship, moving further with the contention.
Your
Point is,
Yes.
it may not be of our liking.
Yes, your lordship.
Some malice intent to
Yes, Your
it,
Lordship.
but was it constitutionally valid or not?
Your lordship,
As per
that
the prescribed procedure.
bill is being disqualified. Your lordship, the time has come that the parliament have to rethink whether the disqualification petition ought to be entrusted to a speaker as a quasi-judicial body on the party swiftly and impartially, thus giving real teeth to the provision contained in the 10th schedule, which is so vital for the parties, Your Lordship. Your Lordship simply stating disqualified, then it would be justified. But speakers is an independent judge, Your Lordship, which is involved. Sure, Your Lordship. Your Lordship, the law is ever evolving, and there can be some procedural flaws in the laws, and that's to state that there are procedural flaws. Okay, it was pleasure arguing with this honorable.
And there is no relief that you are seeking.
Your Lordship, simple contentions of the council was such
They are
that.
not part of the prayer.
Agreed, Your Lordship, but the contentions were such that they are in line with these actions represent an unconstitutional exercise of actions representing the power which they did in the case of Mr. Salim, Your Lordship. Your Lordship. There is procedural loophole. There is procedural loopholes in that, Your Lordship, and the Your Lordship, with regards to the election procedure of speaker and it was pleasure arguing with you. It was pleasure arguing with you. Prevention Act and ancillary issues, Your Lordship. I will be dealing with issue number 1 and 2, and the issue number 3 and 4 will be that by the end of my argument, Your Lordship will be persuaded to be taking 20 minutes each, with 5 minutes being reserved for rebuttal talk. Implemented by the state government of Uttar Pradesh, violates fundamental. Lordship, there has no been step. The state respect fundamental. Lordship, there has no been step. The state respectfully commits there are measures that are being restoring the rule of law. These measures are implemented and are based on mischaracterization of the agenda under the zonal development plan. The classification of illegal structure and their removal serves a legitimate public purpose.
Council, first you clarify.
The criteria of reasonableness.
Your Lordship, as far as I conceive it, as far as the state conceives it, it should not. Your Lordship, principles of natural justice say that. Your Lordship, principles of natural justice say that there has to be opportunity afforded. There has to be opportunity afforded to the person.
Have you provided opportunity to the person?
That's what. Come on, page para 8 of the Moot proposition. There has been zonal plans out. The notice is the thing that all I'm saying that the principle of
Simple query is what are the principles of simple query is what are the principles of should be given.
Indeed, Your Lordship, it is there, but they,
Restrictions take the violation of principles of natural justice.
Your Lordship, none of the natural justice principle has been violated. Your Lordship might see para 50.
Travel to these paragraphs of your page that have been complied with. Come on. And
The provision to section 20, and the fact sheet clearly states that this is the ancestral house of any zoning was done by you under section 10 and section 11 of the Act. That was not subsequent to the, so it can, there be a reasonable presumption that the ancestral house existed before 97 mandatory provision under the provision to section 2.
Action, especially the action of a preventive or remedial nature, right of prior notice and opportunity to be heard may be excluded by implication. In the case of Mercagani, then the case of FEB versus AS Limited also says.
But the statutory requirement under the provision of section 27.
Indeed, Your Lordship, when there is a statutory requirement, what the government is doing as to prevent the misuse of legal loophole, a prompt action need to be taken. The government cannot.
Ancestral house, Mr. Counsel, it was not constructed.
Also says that the house was in very deteriorating state. Just like example, Your Lordship, if
You are mingling up so many things in a way. Number one, determination. Then what is the law on this point? Because
Your Lordship, first of all, the property is illegal. It has been illegally constructed.
I have purchased it. And I have, so is my property illegal?
Your Lordship, they should have shown the documents at that time. They do not have any documents.
Any document without any title. You mean to say that Salim's house, Salim's parents, any document of the title?
No, Your Lordship, because they could not prove.
Where will they prove? What is the procedure of proof?
Before the court, Your Lordship, completely agree.
You are not given any notice.
Your Lordship, that is what I am saying.
What is urgency? Suppose you are doing
Lordship, public purpose all
immediate demolition does not serve. Does it serve any public purpose?
In para 15, second last line, all the documents and the tax file papers.
have to go away. What is the source for the goods? That is source for the candle. We have to give way to the illegal.
For this purpose, what is illegal?
Certificates of different kind, like
The proposition just said that the property is and does not talk about the survey.
Just one clarification. We are banking on the. If you look at the structuring, it's the Indian Constitution legislation, you know? And then you have these executive orders of kind, which is this master plan. Right to property, you have. It's a constitutional guarantee. We are infringing that or taking away that right based on something which is and the only justification we are giving is of urgency. So, what urgency can a master plan have? Instance has very clearly stated that it's not only a constitutional right, it's a human right. A master plan being the basis of infringing or taking away a constitutional right of an individual.
But Your Lordship, all the state is contending if the public disorder or some illegality is there, a prompt action avoid the obstruction further. A prompt action needs to be taken.
You are prompt action. What do you mean by prompt action? Suppose I have made some illegal construction. Public interest will be paralyzed.
Your Lordship, but the state cannot also wait for the
To be a good spectator. Suppose today action will be videopardized. If suppose there is a matter will be
this is not about the one house, Your Lordship. The plan has already been enacted.
In that locality.
No, Lordship, the proposition is very silent on this matter.
See, counsel, with your argument. Okay, come on the points because you have limited.
The action that you will find, even in Albert Alice, the court goes on to say that if
Mr. Counsel, even pavement dwellers in Alcata is case where
or violations of statutory provisions, the demolition of Mr. Salim's property being its duty to promote public welfare and uphold urban planning objectives whatsoever to put forth a claim that he has the protection of Article 21 or for that respect and lies for the right to life and personal liberty. That states duty to ensure of buildings and other structures not only violate the municipal laws and the concept of land development but also affects various fundamental and constitutional rights of other persons also. Your Lordship, seeking protection under fundamental courts are not mean to shield individuals. The state has a duty to protect
The rights of the people are being restricted over here.
your lordship, by removing the illegal encroachment, that's what I am. Reflects bad faith and undermines the principle that one must approach the court with honesty and integrity. Case of S.P. Chandraya Naidu clearly notes that the court of law are meant for imparting justice. Your lordship,
Court with clean hands. You have not provided him opportunity to go to the court. So what is the question to go? You have not given him the opportunity to approach the court to have a recourse to the law. So how can
your lordship, here that when they are coming, they are claiming.
in this contention? Please put your contentions, your submissions precisely. What are your points to justify your
The points
this is
you-
out of point.
Indeed, your lordship. There is no connection to the FIR against him and does not constitute extrajudicial punishment. Demolition of a house is a civil administrative. Be that as it may, on hate speeches, on slogans on government. That is why
You mean to say that there is no nexus and the demolition matter?
Indeed.
Go ahead.
another point, and Justice Chandrachud clearly writes, the ordinary law will not have to be tested on the same veracity as a constitutional provision that for the application of basic structure doctrine. This is not even an ordinary law, your lordship. This is an administrative action. How can it? Your lordship, if the lordships are certain.
So, basic structure of the constitution can be violated under the garb of any.
That-
Government can do that.
No, your lordship, that's not the kind of the case. Or just a mere administrative action be subjected to that kind of degree that it goes on to violate the basic structure of the constitution. your lordship. That's
Again,
not.
Mr. Counsel, you have created a confusion in your submission. What can't be done directly
Cannot be done indirectly.
In a power of delegation or sub-delegation, you can do that as an administrative order. You mean to say that if that is anything in that regard,
Civil.
you mean to say that? So you
The
have
council
taken-
never contended that, your lordship, motion as contended by the petitioners, your lordship. That's all the council and the state is contending, your lordship.
I don't know how can I say that.
Ultimately the ball is in your lordship's courtroom. My point is to make. Sure. Lordship, I like to move with issue number 2. Whether paragraph 2D of the 10th schedule of the Constitution violates the constitutional right to represent circumstances such as widespread civil unrest and political instability. It is submitted before this honorable court that paragraph 2(1)(b) of the 10th schedule of the Constitution does not violate the constitutional right to represent one's constituency. It talks about the disqualification of the members who abstain from voting or vote contrary to an election issued by the political party like to raise. Your lordship, in Kyoto, a 5-year bench of the Supreme Court has already upheld the 52nd Amendment and the anti-defection law. Your lordship, the court upheld the constitutional validity of all the power of the judicial review. All I am saying that when the constitutional validity has already
This amendment at 1952 is very 52 amendment
is to cure the defection and the process of defection and whatever comes with it. The court only refer to the object of the act, that the object of the, on that point it upheld the constitutional validity. All I am saying, a review of that case cannot be taken through a writ jurisdiction, your lordship. Provision paragraph 2(1)(b), they can file a review petition of the Kyoto Hold, they are free to do so, but they cannot do National Lawyers Campaign for Judicial Transparency and Reforms case that Article 32 petition does not lie section is indirectly taking review of the Kyoto Hold case.
Address the bench gently as a lawyer. Now starting with issue 3, it says that whether the correct or not. So I will be dealing with this issue in two-fold mechanism. how this is constitutionally valid and follows the democratic principles, and as well as then I will be dealing with how it is it is in consonance with fundamental. Firstly, coming to the constitutionality of this particular issue, the election deputy speaker is fundamental to the democracy of a country like India, as it derives its authority directly from the Article 78. It says that every legislative assembly of a state shall choose to. So we want to individuals from the house. Now coming to the case of R.S. Nair, in this case it was clearly stated that the process is a cornerstone in a democratic practice, and it ensures that the speaker.
Just a minute. Council, the question here is, and that's what is raised by the petitioner,
Yes, sir.
that the process of this parliament, whatever may be the case, so that is not, that is against the right.
Yes, Lordship.
You
Very
have
well.
to establish that even if from the ruling party, then how are you going to say that it is fair?
First of all, there has been an assumption that the ruling party itself will always choose the speaker and the deputy speaker. So that it will always not be the case that the ruling party chooses the speaker.
So will it come from the majority party or minority?
Your Lordship, when we are talking about majority in this case, it is talking about the numbers in the. But it goes on to say, like in our case as well, that the speaker. Ruling party. It goes on to say that the speaker is not from the ruling party, that apart from the choice of the ruling party, that this upholds the mechanism that is still there in place. And here,
In this regard, what is the concept of constitutional validity?
Your Lordship, I just mentioned that how they basically represent the collective will of the House. Speaker are the chair. And
Council, either are not getting the question of pro judge or you don't want to answer.
But maybe there may be other students of law if we do not.
your question because I do not
Because you
understand.
That
I
is wasting your time.
the appointment of these particular speakers and deputy speakers, and the will of the people are in this regard.
It does not have anything to do with the morality or immorality. That is written, there is no written constitution.
Yes, sir.
Conventions, which convention is being held in their country. Written constitution, but they have a provision, they have a convention that is respected, this convention. So, this
Constitution that has been mandated itself. Here as well in the case, in the present case itself, they have derived the clause for schedule themselves. Also, in the case of Kyoto Holocaust, the speakers possess excessive judicial scrutiny, and we contend your lordship that has been irritated by the court. Coming to the rules. Speaker of the Legislative Assembly is constituted has been governed by the rule of this provision, this statute from the Deputy Speaker to represent their case itself. Now coming to that, even if the Deputy Speaker as well, because he is acting as in a quasi-judicial role right now. When the
Election is very tough.
Your Lordship, I am
The
talking.
issue is very clear.
Yes,
Whether
sir.
the country is valid or not. What they have done, the
Yes, sir.
action of the deputy speaker is not to be proved.
Not to the answering the contentions of the petitioners. So basic framework. Now to question that will also be questioning other cases that I have cited, maintain that fundamental rights code Indira Gandhi versus Raj Narayan. In this case, Justice Chandra, whether it was whether the must be there it should not be violated, and also covers that in addition to other provisions of the Constitution. Now coming to Article 19(1)(a), Article 19(1)(a) is also not being breached, because if 1A is also not being breached, because if we talk about freedom of speech and expression, in the case of Muhammad Hanif versus speech and expression, in the case of Muhammad Hanif versus because they have also mentioned there should be a focus on public interest. 50 focus on public interest. 52nd amendment totally useless because then the defection would happen. 94 talks about the immunities of that have been given.
Why we are discussing parliamentary privileges to establish whether
on biasness based on deputy speakers said there. But basically 194 has been mentioned because coming to the case of State of Rajasthan versus Union of India on page number 40 of a written particular tribe, whether or not someone was from this particular tribe, whether or not someone was from this particular political party. There has been no mandate in the rules 8 and 9 that, like the fellow counsel said, questioning this would be questioning Tigoto Hollow, and the pro on pre-trial detention without formal charges are inconsistent with the protection of with the objective of preserving the national security interest. Now here we contend that unlawful activity and terrorist act has been precise and delineated manner that only actions which jeopardize the national security have been booked under this particular.
We need very wide and comprehensive. Right? It gives lot many of example in that section. So
the definition of terrorist act has been defined. We contend that it is not overextended. Now coming to
no. What the petitioner has challenged, they say we brought within the definition of these are brought here. Use proper of these are brought here. Use proper
execution victim family says that unlawful activity includes action intended to assert or advance any activity as its objective. In this particular instance, number 35 of the Moot proposition you might find the petitioner's action definition of 35 of the Moot proposition you might find the petitioner's action definition of under section 2 and 15 itself procedure under section 2 and 15 itself procedural safeguards, but also time and time again this honorable court has given decisions to uphold the validity of UAPL. Now
The question is, let's link with the facts of the case. There's a widespread media link with the facts of the case. There's a widespread media to be inflammatory or power in the hand of the administration, and there's a judicial oversight which has been inbuilt in this one, not allowed.
You want to bring into sweep, you can do that according to your fancies. So answer that query.
Your Lordship, first of all, during
Talking about division.
Your Lordship talked about 43D5 as your Lordship was saying that now if we talk about
That is okay. there is no hope to conclude the trial in near future on bail.
Yes, Your Lordship.
Because the law of the land says, according to section 43D5, that what is your stand on this point?
Your Lordship, this is the case where we are talking just about 180 days because of UP where it was held that constitutional courts is over private interests. Now, just pressing in for an alternative system for the same.
Lordship, the council
For
permission of this honorable court to approach the dais for rebuttal.
That is your right.
Much Your Lordship, there are similar fellow respondents, Your Lordship. We have the right to approach this honorable court and contentment that they contended. We were not police authorities as a part of the state. They are, Your Lordship, whenever you approach my house, you certain documents we have provided with some documents. Your Lordship, third point, section 152, Your Lordship, they are stating that a district magistrate or a sub-divisional magistrate or any other information and taking such evidence, the magistrate to demolish our property.
starting with the deteriorating state, the house was have been there from ages, but since the FIR was registered and then the investigation might have towards the FIR was registered and then the investigation might have towards the safety and security and also the MLAs. They have mentioned that the present safety and security and also the MLAs. They have mentioned that the present that cannot be the case always. If we go on, it would increase, it would not decrease, and this would increase, it would not decrease, and this is the case here. That and even if they did not want to against us 5-2, which the Houses of Parliament, but still, if we give that error also, it mentions any court, the UP rules. Now, purpose of the 10th schedule, if we acceptable who have been, anybody would hamper in the state, in the legislature.